Hi, Melissa, you're now the co-host. I'm getting out.
Go in.
Good morning.
Good morning, Laurel. How are you?
How are you?
Good, thank you. Good morning, Sarah.
Good morning.
How are you today?
I'm great. How are you?
I'm doing well, thank you.
Good morning.
Good morning, Jim.
Hi, Jim.
Melissa, do you, Pat is joining on his, he's having to do this with his phone. He resides in northern Maine now, and he has health issues, so he is doing this as best he can from home. So he should be joining. He has my number if he had any issues. We went over it yesterday. So I expect that he should be.
I think that would be him as a P.
I hope, yes.
Okay.
Tim, can you tell me how to pronounce his first name, please?
Pasquale. He goes by Pat.
Thank you.
Pat, can you hear us?
I can hear you now.
Can you get a screen on, Pat? Can you do a video?
I got you on video. I'm not sure. I typed in that. Let me see. Evidently, it's not. I got you in a corner and I can't. No, it won't go.
I don't have a problem with proceeding without video for Pat as his counsel, but I don't know how everybody else feels.
I can see you. I can hear you. My phone will not. It won't put me on for some reason.
Are you on an iPhone?
No, I'm on a Android, Samsung.
Can't help you there.
It's the same. You should just be able to turn your camera on.
Well, I see it, but it won't let me do it. I keep punching it and it just puts you in the corner and puts me up as a symbol only, not a live picture. But I can see you people.
Does anyone have any objection?
Nope, I don't object.
Okay.
I
Erica?
do think we need to confirm that. Oh, I'm sorry. I do think we need to confirm that it is Attorney Perrino there. But as long as that is confirmed, then I have no objection.
Want a verbal acknowledgement that it is me?
I can also suggest that I don't think anybody else has this link. Pat certainly got the link from me forwarding it from Melissa yesterday. So I don't think there's a serious issue that it's not Pat.
The only thing I saw in the pleadings that was just sent to me, Jim, is my bar number is wrong. My bar number is 1675. I think it was on the waiver that you sent me.
Yeah, it's actually on the app. It's on both signature blocks, Audrey.
Okay.
Thank you for correcting that.
And we'll fix that. And I suspect the fact that Mr. Perrino has been able to identify that his bar number is wrong is sufficient to establish his identity for everyone's satisfaction. If I'm wrong, please let me know.
Mr. Balls, are we expecting Ms. Lovell?
We are not. She will not be here. I'm here representing her in a monitoring capacity.
Okay. Thanks.
You're welcome.
On that note, Sarah, everybody that we are expecting then is on.
Excellent. Thank you. Then we'll begin.
Okay.
This is a disciplinary hearing conducted before Panel D of the Grievance Commission of the Board of Overseers of the Bar in the matter of Board of Overseers of the Bar versus Pasquale Perrino Jr., file number GCF 2174. I am the chair of this panel. My name is Sarah McPartland Good, and I'm an attorney in Orono. Joining me on the panel are Erica Veazey, who is an attorney in Bangor, and public member Richard Dana, who's a CPA from Cape Elizabeth. The date is September 20th, 2022, and we started right around 10 o'clock. In attendance are Assistant Bar Counsel Audrey Braccio, respondent who is participating by telephone, Pasquale Perrino. Respondent's counsel is James Bowie. The complainant's counsel is Lee Balls. Board Clerk Melissa Littlehale is here to serve as a resource to members of the hearing panel for any administrative and procedural matters that may arise. And Laurel Long is also here. The hearing is being recorded by a court reporter pursuant to Maine Bar Rule 14A6. In order to make Laurel Long's job less taxing, please make every effort to speak clearly and please refrain from interrupting one another. The parties have previously had an opportunity to object to the composition of the hearing panel and no objection has been received. Would the parties both please reaffirm that they have no objection to the panel's composition at this time?
That's correct. I have no objection. I did want to put on the record, Attorney Veazey works for Pine Tree Legal Assistance. I am on the board of Pine Tree Legal Assistance. However, I talked with Attorney Bowie about that previously, and he confirmed that he has no objection. So no objection to the panel composition for the board, but I did want to make sure that was on the record.
And no objection from the respondent.
Thank you. This is an open public disciplinary hearing conducted pursuant to Maine Bar Rule 13E7. The hearing is simultaneously live streaming on the board's YouTube channel. The parties have filed a proposed stipulated report of findings and order in this matter. The only issue before the panel is whether to adopt or reject the proposed stipulated report of findings and order pursuant to Maine Bar Rule 25A. If the panel rejects the proposed stipulated report of findings and order, this matter will be then set for hearing before a different panel of the Grievance Commission. And as a result, the stipulated report of findings and order and any affidavits that are submitted pursuant to Maine Bar Rule 25B and D cannot and will not be used against the respondent in that or any subsequent proceedings. Would Bar Counsel or Respondents Counsel care to make any preliminary or opening statements regarding the proposed findings or proposed report of findings?
Well, I'm happy to do whatever is most helpful to the panel. I can give some preliminary comments if that would be helpful, or if you want to jump straight into questions, I'm happy to do that as well. So whatever would be most helpful for the panel.
I think a statement would be helpful.
Oh, you're on.
Audrey, you're muted.
Thank you. So I'll be brief because the stipulated report does describe the facts here, but in summary, the complainant DL hired attorney Perrino to represent her in a divorce case in May of 2018. Thereafter, in March of 2019, they began a consensual sexual relationship while her case was still ongoing. So main rule of professional conduct 1.8J is the rule that applies here. That rule became effective in October of 2018. So it was in effect at the time of the conduct here in 2019. And that rule states, a lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. So as you can see in the stipulated report, Attorney Perrino does not contest that his conduct violated Rule 1.8J. With regard to the appropriate sanction, we're asking for a reprimand. And Bar Rule 21 lists the factors to be considered in imposing sanctions. We believe a reprimand is appropriate here, given the level of potential harm, as well as the aggravating and mitigating factors. So in terms of harm, the complainant in this case does feel the relationship between them impacted Attorney Perrino's representation of her. However, my office did not receive any specific evidence showing a negative impact on her case or other harm. Regardless, though, the misconduct certainly put the client at risk of harm. So there's at least a potential injury here, which is more than minimal. With respect to aggravating and mitigating factors, an aggravating factor in this case is that the client was in vulnerable circumstances, given that she was seeking help with family law issues and a difficult divorce, as well as the power imbalance, which is one of the concerns underlying the rule. There are mitigating factors here as well, though. One of them is that the conduct appears unlikely to be repeated. Attorney Perrino has been on inactive status with the bar since October of 2021, so almost a year. And it's our understanding he doesn't intend to return to practice. And then also the nature of the misconduct suggests that it was an isolated course of conduct. In addition, Attorney Perrino's admission and his cooperation with this proceeding is a mitigating factor. So with the combination of those factors, it's the board's position that that lands this case in the category of a reprimand. And we're requesting that the panel accept the agreement of the parties and impose a public reprimand pursuant to the proposed order that was submitted. We're also requesting that the order include a condition that Attorney Perrino be required to disclose this reprimand in the event he applies for emeritus status to be able to work with a legal services organization, so that that organization could then take any additional precautions or oversight that they feel might be appropriate. Thank you.
Okay, thank you. Mr. Bowie?
I also will be brief. Audrey's recitation is essentially accurate. I have a couple of other items just to give a little bit of background. My understanding is that the complainant's divorce had been pending for some time prior to Mr. Perrino undertaking her representation in the already pending divorce in in early 2018. He did continue to represent her. A judgment was entered in January of 2019. The relationship began thereafter, but there were post-divorce matters pending at the time he entered into the relationship with her. And as a result, we agree that there was a violation of Rule 18J. There is, as Bar Counsel noted, the complainant believes that the relationship may have affected Mr. Perrino's judgment. While that issue is hotly contested, it is the focus of incipient litigation entirely apart from this proceeding, just so the board understands that that is out there. I would point out that Mr. Perrino has no prior disciplinary record in mitigation. He had a very limited practice when he represented the complainant. He has not engaged in the active practice of law since this case ended, and for a variety of reasons, including health and other reasons that are reflected in some of the items that were filed as part of the bar's investigation. It is fair to say Mr. Perrino will not be actively practicing law after this. Under all of those circumstances, this seems to be precisely the type of case that is appropriate for a reprimand. We agree with the analysis set forth both in the stipulated order and in the representations made by Bar Counsel Bracchio, and therefore we ask that the panel accept the stipulated order, and we also agree to the stipulation within the order that in the event that Mr. Perrino were to seek to merit a status in order to allow him to provide any other services, he would have to disclose this reprimand.
Thank you. Mr. Balls, would you like to make a statement on behalf of your client regarding the proposed report of findings?
No, thank you.
Okay. All right. Mr. Dana, do you have any questions that you would like to ask the attorneys?
Yes, Attorney Balls, is DL satisfied with the stipulated report and the sanction?
Yes, I've consulted with my client. She is. And as Mr. Bowie mentioned, there is a collateral proceeding that continues in the civil courts. So the simple answer, Mr. Dana, is yes.
Thank you. And Attorney Perrino, are you aware of the seriousness of 18J?
I am.
And I understand you won't be practicing again, but that rule took a lot of effort because of a lot of bad things. So we try to impress on attorneys the importance of that rule. So thank you. And those are all my questions.
Ms. Veazey, do you have any questions?
I do not. Mr. Dana asked exactly the questions I had, so I'm satisfied. Thank you.
Thank you. My only question was with respect to the way that the stipulated formal disciplinary charges petition differs from the order. And I think it's been explained to me that although the petition asks for reprimand and probation, there was a change of mind, and now you are simply seeking a reprimand. Is that correct, Attorney Bracchio?
Yes, that is correct. That was an error by my office to include the reference to probation when we sent those initial documents. That's something that I think had been discussed earlier in the case, but given the current circumstances, and in particular that Attorney Perrino does not intend to return to active practice, we are not asking for probation at this point and are simply asking for a reprimand with the condition.
Okay, thank you. All right, does anyone feel the need to make any sort of closing argument?
I don't. I would just note, because of the logistical issues, particularly with these Zoom proceedings, normally, because I have limited organizational skills, I have my client execute the waiver and the affidavit at the hearing. That isn't possible. So I would just ask briefly that Mr. Perrino acknowledge that the contents of the affidavit be accurate, just so that that part of the record is clear. And we will indicate that he waives, if the board accepts the proposed order, that he will stipulate to a waiver of any petition of review. So I, just as a a way of keeping house here, given the difficulty with pushing the paper, I would suggest we do that. If that works for Audrey, I don't know. I hadn't had a chance to discuss this with her in advance, so I apologize for dumping this all of a sudden.
That makes sense to me.
Is the affidavit that you're referring to the affidavit that's required by Maine Bar Rule 25?
Right, and we will file a written copy, but just time-wise and logistics-wise, I just thought if everyone agrees, I'm just going to ask Pat. I will go through the 5 items of the affidavit and confirm on the record here that they are in fact correct.
And you indicated that you are also going to have him sign a waiver of petition?
Yes.
Okay.
Mr. Perrino, you have reviewed the stipulated report of findings of the panel, and you have discussed it with me. Is that correct?
I have, and yes,
And you consent to the approval of the stipulated report?
I do.
And your consent is freely and voluntarily rendered, and you're not subject to any coercion or duress. Is that correct?
That is correct.
And you understand the implications of the consent based upon our conversations and your review of the order, correct?
I did, yes.
You're aware there's a pending proceeding and that allegations within that proceeding would provide for discipline, and that those allegations are set forth in the stipulated report.
Yes,
And you acknowledge that the material facts alleged are true or could be proven, correct?
yes,
And you stipulate that sufficient evidence exists to support the findings set forth in the stipulated report and the imposition of the stated sanction, correct?
I do, yes.
And if the board chooses to accept the stipulated report, you do waive any petition for review of reprimand, correct?
I do.
And you would authorize me to execute a waiver on your behalf, is that correct?
That is. If I have to sign anything, Jim, you'll have to send it to me snail mail, because I don't have the capability of printing.
Yeah, I understand that, which is why I asked to be able to sign the waiver for you, and why I wanted to put the contents of the affidavit on the record, since that is essentially the same as filing a written affidavit.
Good. Thank you.
Okay. Well, thank you for your courtesy and cooperation. The public hearing is now closed, and the panel will meet privately in a breakout room to deliberate. And I would ask everyone please remain in this room until the panel returns. And I'm going to ask Ms. Littlehale to join us in the breakout room should we need any administrative or procedural assistance. So we will return to the meeting and announce our decision on the record. Thank you. But Melissa, how do we get to the breakout room? Oops, you're muted.
I'm creating it and I'll assign you right now. Just give me 1 second.
Okay.
Thank you.
Audrey, if you're still there, I realize you just popped up. I apologize for this. If the staff up there were not entirely new, people would know that I always mess this up, and I at a live hearing, I'm viciously finding my copy and having my client sign. So I apologize for that.
Yeah, it does make sense to sign it when you're right there, but I guess with these Zoom hearings, we've got to adapt. But I think that works fine.
If Lee's still listening to you, he can confirm, since we dance together a lot, that my organizational skills are severely limited.
I heard you say that earlier, and I was going to stipulate to that if I had an standing to do that, Jim. So, yeah, yours rival mine, Jim. We're quite a team. Hey, Jim, I just want to mention to you, I got a call. John Chase died yesterday.
Oh, I did not know that.
Yeah.
Wow. Huh. He wasn't that old.
No, I don't think he was in terrific shape, as you probably recall. Yeah.
Hmm.
No, I think he was probably in his early 50s.
Yeah. It's too bad. Pat, are you still there? You just lit up.
I am.
Okay.
I'm just listening.
I hope my confession as to my limited organizational skills hasn't caused you any concern.
You compare them to mine, they're excellent.
Julia, are you there?
I am actually.
As I got ready for this, I pulled up the website and I see that you got a result in Michael Chinquette.
Yes, we had the panel finding and then it was reviewed by a single justice. So we did.
I knew that was out there and I was wondering when it was going to get resolved.
It's an interesting case.
Well, it was also interesting that there was obviously a fair amount of discussion of Peck, which was my case, but Jim Martimucci represented one of the other respondents in that case as well. So he was very familiar with all of that.
That's right. That's right.
While I've got you, the other piece is that we probably ought to talk about that MacDill piece and figure out what we want to do.
Absolutely. Yep. No, we should. I agree. And I don't know if it's a Zoom presentation. So if we want to put together some kind of a PowerPoint, we can do that. I don't know if, those are sometimes helpful to people. I guess it depends on how we're going to present.
Yeah. I mean, my guess is that we're not going to be terribly far apart on where we're at with that, with that issue. I mean, it's basically you got to represent your client, but you got to be careful.
Mm-hmm. Right.
So, I mean, obviously, my guess is that we may have slightly different perspectives on that, but I don't think they're going to be all that far off.
Mm-hmm. No, it'll be an interesting presentation. I'm looking forward to it. It's an interesting topic.
Yeah, it is. The prosecutor side of that, dealing with whether a prosecutor can address a represented but uncharged individual and so forth, was really interesting when we were putting together the rules, I was on the task force, and the main prosecutors were fine with the rule. Paula and the federal prosecutors were not happy with the rule and wanted much less of a requirement that the prosecutors involve defense counsel. It was just interesting to see the difference. I think it was the Thornburg memo. Is that what it is? You know,
Yeah,
so
no, it was, and it's, yeah, well, I mean, I think that it comes from the different kinds of cases, and the different kind of prosecutorial work that's done.
So we will be returning in just a moment, okay?
Yep.
Let you guys know.
Jim,
Yeah.
is Alan Kelly now all retired now? from the
Yes,
board?
it is, Pat, and we're all back, so. Okay,
Okay, it appears that we are all back. And the panel has deliberated and decided that we accept the agreement of the parties. I understand that Ms. Littlehale is going to be asking for the stipulated report of findings and order of the panel to be revised to reflect the correct bar number and another item. But when that's put before the panel, we will sign it. But taking all of the factors into consideration and consistent with the analysis outlined in Maine Bar Rule 21C, the panel commission will sign an order that imposes the following sanction. Attorney Perrino will be reprimanded by the Grievance Commission pursuant to Maine Bar Rule 21B5. And as a condition of the reprimand, in the event that Attorney Perrino applies for emeritus status to provide pro bono services, he shall be required to disclose the existence of this reprimand to any legal service organization with which he will be working. So I want to thank you for your participation today. And Melissa, is there anything more?
I think that's it. Mr. Bowie, you will send me the affidavit in the waiver petition?
yes, I'll send you the waiver directly because I've been authorized to execute it on behalf of Mr. Perrino. The affidavit needs to be signed by him, so that may follow along a little longer, given the fact that it'll be done by mail.
Okay, perfect. And that's it. That's all I have, Sarah.
All right, great. Thank you so much, everyone.
Thank you, everyone.
Thank
Bye-bye.
you. Have a good day.
Bye.
Bye-bye. Mr. Perrino,
Yes, ma'am.
you can exit the meeting. Everybody's gone.
I gotta figure out how to do that.
Okay, let me see if I can end it for you, and then that would automatically kick you out.